In a landmark decision on April 25, 2025, the Pennsylvania Supreme Court settled a heated debate about who can access mugshots under state law. The case, Tricia Mezzacappa versus Northampton County, revolved around a simple question. Can a county release mugshots to the public under Pennsylvania's Right to Know law, RTKL? The court's answer was a resounding no, reversing lower court rulings and clarifying the intersection of the RTKL and the Criminal History Record Information Act, CHRIA. Here's what happened, why it matters, and what it means for you. The basics. RTKL and CHRIA explained. The Right to Know law, RTKL, is Pennsylvania's tool for transparency. It lets anyone request public records from government agencies like counties, cities, or state offices to keep officials accountable. But there are limits. Records tied to criminal investigations, for example, can be off limits. Then there's the Criminal History Record Information Act, CHRIA, a law designed to protect sensitive information about people involved in criminal proceedings. CHRIA covers things like arrest records, charges, and identifiable descriptions of individuals, details that help pinpoint who someone is. Under CHRIA, only certain agencies, like police departments, can share this information with the public, and even then, only under strict rules. What happened in the case? Tricia Mezzacappa wanted mugshots, those photos taken when someone's arrested, from Northampton County. She filed 2 RTKL requests in late 2020, one for mugshots of 2 specific inmates, and another for all mugshots taken at the county prison over several months. The county said no, arguing that mugshots were exempt under the RTKL because they're tied to criminal investigations and protected as identifiable descriptions under CHRIA. They also pointed out that CHRIA only lets police departments, not counties, release this kind of info to individuals. Mezzacappa appealed to the Office of Open Records, OR, which sided with her. The OR said mugshots aren't necessarily criminal history record information under CHRIA, just photos, not detailed rap sheets, and ordered the county to hand them over. The county fought back, taking the case to the Northampton County Court of Common Pleas, and then the Commonwealth Court. Both courts agreed with the OR, saying mugshots weren't identifiable descriptions, and that CHRIA didn't stop the county from releasing them, but the Pennsylvania Supreme Court saw it differently. The Supreme Court's ruling. In a unanimous decision penned by Chief Justice Todd, the court tackled 2 big questions. Are mugshots identifiable descriptions under CHRIA? Yes, they are. The court dug into the meaning of identifiable descriptions in CHRIA, which defines criminal history record information as data collected by criminal justice agencies, including identifiable descriptions of individuals involved in criminal proceedings. The Commonwealth Court had argued that this term only covers written details, like height or eye color, not photos, but the Supreme Court disagreed. Using dictionary definitions and common sense, they ruled that a mugshot, which instantly identifies someone, fits the bill. After all, a picture is worth 1,000 words, and a photo is often the best way to identify someone, more so than any written description. Why this matters? This ruling isn't just legal jargon, it's about balancing transparency with privacy. Mugshots are more than just photos. They're tied to criminal accusations, which can carry stigma even if someone's never convicted. The Supreme Court recognized that CHRIA exists to shield this sensitive info, protecting individual privacy while still allowing controlled access through proper channels, like police departments. By classifying mugshots as identifiable descriptions, the court ensured they're treated with the same care as arrest records or charge details. It also clarifies who's in charge of releasing them. Back in 2020, when Mezzacappa made her request, state or local police could share mugshots with the public upon request. But here's a twist. CHRIA has since changed. As of February 12, 2024, only the Pennsylvania State Police can release criminal history record information to individuals. Other agencies, like local police or counties, can only share it for their own law enforcement purposes. So even if Mezzacappa tried again today, she'd have to go straight to the state police, not the county. What it means for you. Thinking about requesting mugshots or similar records. Here's the takeaway. Counties are out. Don't bother asking a county government for mugshots. They can't give them to you under CHRIA, as this case confirms. Check the law's timing. If you're digging into older records, pre-February 2024, state or local police might have been able to help, depending on the rules back then. For anything now, it's the Pennsylvania State Police or bust. Privacy versus access. This ruling leans toward protecting privacy, so don't expect mugshots to pop up easily in public records. You might find them elsewhere, like court filings or news reports, but RTKL requests to counties won't cut it. This case shows how tricky the line is between open government and personal privacy. Mugshots might spark curiosity, but they're legally sensitive. If you're navigating these waters, knowing the right agency and the right law is key. Disclaimer: this blog post is for informational purposes only and isn't legal advice. For help with your specific situation, contact a qualified attorney. J. Chadwick Schnee, Esquire, practices at Schnee Legal Services, LLC, helping clients understand and navigate Pennsylvania law. Questions? Reach out to us.